you don't learn the law in the United States the way you learn it in France or in Europe. There is a reason for that. Usually, the way of teaching law and everything in the United States is more fun. There is a lot of fun, there are gimmicks, there are ways just to make it appealing to the students. And usually it's a success. In France, it's more severe, serious, and all over Europe, this is the same. In Asia, it's a little bit a mix-up of both. There is another reason for the difference of the law of teaching law and learning about law and studying law in the United States and in France is that both systems of law are completely different. The civil law of France is inspired by the Napoleon Code, which was edicted like more than 200 years ago, where the law is created by the Parliament, Assemblée Nationale and Sénat, and then put in motion by décret from Conseil des Ministres, Président, a mix-up of both and other institutions, and règlement from lower centers of power. Then the courts, lower courts, Supreme Courts are here to interpret the law, but within a very small and narrow range. It's not like in the United States where the judge is extremely powerful. In France and all over Europe through civil law, like in Germany, in Italy, in Spain, the judge can just interpret, I would say, a little bit the law which has been voted by the parliament. In fact, you can go online and find the law, and not only the lawyers, but any citizen can go online and get 95% of the judicial system and the law and understand what the citizen can do and not do. It's all available. In the United States, as we know it, it's different. The law is not created by the parliament, but is created by the courts. This is the court who decides what is the law. From time to time, there is a codification of the law which is made by the Congress through acts of Congress or statutes which are voted by the parliament of each of the 50 states. And this is the exception. But mainly, the law is created by the courts and by the judges. So this is a main difference that sometimes students have difficulties to understand. Not only students, because in many areas of law, the consequences of both systems are completely different. Not only the functioning of the law, but also what the law says. It's very often between Europe and the United States, and especially between France and the United States, counterintuitive, or the law is the opposite. Let's talk about negligence, for example, where in France it's recommended and punishable by law if you don't help someone who's in danger or suffering or hurt. This is your duty to act as such, and if you don't, you may be prosecuted criminally, especially if you're a physician or a nurse. In the United States, for example, in the state of New York, it's different. The duty of care is very loose by a standard to help someone in the street who has been hurt. You may help the person or not, but you don't have a duty to help the person unless it's your spouse or your children or you contributed in harming the person. But if you have no duty to help the person in the street who has been hurt, and you do help the person, then your liability may be put in motion. You may be sued for negligence and have huge damages to pay. So before you say, I know, I would recommend the students, this is what I recommend in my classes, is to think and answer, it depends. It depends on the system of law which is adopted, it depends on the country, it depends on the judge. So be cautious and don't make bold assumptions and try to understand the different angles of the law operating in different systems and different countries.